video, we're going to try our hand at some practice questions. These questions will be focused on the sections of the rules that we've already covered so far in the course. Before we turn to our practice questions, I want to discuss a general approach to answering multiple choice questions, specifically your MPRE questions. And this approach might slow you down at the beginning and while you're practicing it, but ultimately it is going to make you faster at answering these questions. I always like to point that out because, of course, the MPRE is a timed exam, and oftentimes many people struggle with timing. So when I talk about this approach, people often say, wow, this is going to take me forever to get through questions using this approach. And of course, that's an extra stressor. So I don't want to stress you out, and I want to acknowledge the fact that yes, this process will slow you down, but ultimately it's going to help you speed up. So let's turn to that approach. First, we recommend you read the fact pattern, and then the call of the question, and then you stop. Some people like to read the call of the question, and then the facts, and then the call of the question again. And if that works for you and timing's not an issue, then go for it. There's definitely some flexibility there. So here together, I'm going to read the facts and then the call of the question, and then I'm going to show you how to dissect the question. I would urge you to cover up the answer choices. This way, if you're tempted to take a peek at them, you won't see them because your hand will be over them. Ideally, with this approach, after you've read the facts and the call of the question, I want you to get in the habit of asking yourself, what rule is this question testing? And forcing yourself to think through that rule. Once you've articulated the rule that applies, then apply it to the fact pattern. And you're doing all of this in an effort to try to reach a conclusion by yourself. Then once you've articulated a conclusion to yourself, that's when you would uncover your answer choices and try to find one or match one that is the answer you came up with. The point of all of this is it's going to help point you in the direction of your weaknesses. For instance, if you can't articulate the rules being tested, that's a big red flag. That should tell you you need to get back into that outline, work on understanding, and work on memorization. Now, let's say you can articulate the rule being tested well, but you're struggling applying it. Okay, well, this means maybe you need some help understanding that rule, but it more specifically means you need more practice. However, most people do not struggle with application. As it relates to the MPRE, most people struggle with knowing the rules or having them memorized. The other really great part about implementing this approach is remember, MPRE questions are tricky. So if you get in the habit of forcing yourself to slow down and reach a conclusion on your own without jumping into those answer choices for guidance, you're way less likely to fall into one of those traps that are present on a tricky question. Finally, once you've picked an answer choice that you think matches the answer you articulated, always take some time to double check those remaining answer choices. Make sure you are positive that they're wrong. So again, I know that this is a process and it is definitely time consuming. Like I mentioned, it's going to slow you down, but it's an indispensable part of this process. It is absolutely necessary for your success on this exam. So now that you know the approach, that's how we're going to practice these questions together. So let's turn to question number 1. The facts state, an attorney agrees to represent a plaintiff in a negligence case on a contingency fee basis. After the client retained the attorney realized that he needed the assistance of someone who was more familiar with the complex medical issues that were at issue in the case. The attorney thus consulted an attorney who had specialized in medical malpractice. The two attorneys agreed that the other attorney would assist with the case to the extent needed and that the attorneys would divide the fee proportionally to the services performed by each attorney. The plaintiff was not told about the arrangement. Once the case was concluded, the attorney provided the plaintiff with a statement that explained the fee division. The total fee was reasonable. Was the arrangement between the two attorneys proper? So turning to our approach, we know that step 1 is trying to articulate the rule that's being tested by this question. The rule that's being tested here is the ability of lawyers to share fees. The model rule tells us that lawyers shall not share fees with another lawyer. But there are two exceptions to that rule. The first exception is that lawyers in the same firm can share fees. Now, stopping there for a moment, that doesn't seem applicable to our facts. We do not have any facts that support the conclusion that these lawyers are working together in the same firm. So let's turn to the second exception. The second exception says that lawyers in different firms can share fees with one another if three basic requirements are met. The first requirement is that the fee is divided proportionally to the amount of work that each lawyer did, or the lawyers are going to be jointly responsible for the case. The second requirement is that the client is told about this arrangement and they consent to this arrangement in writing. And the third requirement is that the total fee charged to the client is ultimately reasonable. Here, it sounds like that might be the situation that we're dealing with. Because again, we do not have facts that support the idea that these two lawyers are working together in the same firm. So let's double check our fact pattern to see if the three requirements for fee sharing are met. Because if not, then this was not proper. So turning to that requirement that the fee is proportional to the services performed by each lawyer. We have a fact that specifically tells us the lawyers agreed that they would divide the fee proportionally to the services performed by each. So that requirement appears to be met. Another requirement is that the total fee remains reasonable. We also have a fact that specifically states the total fee was reasonable. So that's two of our three requirements. The final requirement is that the client knows about this fee sharing agreement and it's confirmed in writing. This appears to be the issue because the facts specifically tell us the plaintiff was not told about this arrangement. In other words, this client was notified after everything was said and done. So turning to the call of the question, as a reminder, it asks, was the agreement between the two attorneys proper? And based upon our discussion, we do not believe the arrangement between the two attorneys was proper. Why? Because the client did not consent to this fee sharing agreement. So at this point in our process, we uncover our answer choices to see which one matches what we just said, and to then evaluate those remaining answer choices. For ease, let's start with answer choice A. It states yes, because the fee paid by the plaintiff was still reasonable. A is a great trap answer because it articulates some of the rule, but not the whole rule. And as we learned, this is just one of the three requirements in order to have a proper fee sharing arrangement. So that's why A is wrong. B says yes, because the attorneys divided the fee in proportion to the amount that they each worked on the case. Similarly, B is like A. It's a good trap answer. It's a good answer for someone who kind of knows the rule, but doesn't really know the whole rule. So again, this is wrong because sharing the fee proportionally between the two lawyers is necessary, but it's just one of the three requirements. So B is wrong. C says no, because the plaintiff was not advised that the other attorney was working on the case. So C looks pretty good. That's what we articulated. But let's double check to see if D is wrong. D says no, because the attorneys from different firms are not permitted to share fees. Well, answer choice D is wrong because as we've learned, the general rules that lawyers shall not share fees with another lawyer. But we have also learned there are two exceptions. And one exception allows lawyers from different firms to share fees so long as those three requirements under the rule have been met. So D misses that point, which makes C the best answer. Let's use that same approach with question 2. So we're going to start with the facts. A family law attorney and therapist frequently referred cases to each other. One day, the therapist approached the attorney and asked the attorney to form a partnership with her. The therapist had a very good reputation in the community. The attorney also had a good reputation and was known as being honest, competent, and giving candid advice. The attorney agreed to form a partnership with the therapist, provided that only the attorney gave legal advice. The therapist agreed to this arrangement. the firm's stationery and website were changed to reflect the partnership and to also reflect the fact that the attorney is the one licensed to practice law and that the therapist was a certified therapist. Is the attorney subject to discipline if he enters into the proposed partnership with the therapist? Okay, so stopping there and getting in the habit of asking ourselves, what is the rule being tested by this question? And the rule that seems most applicable is that lawyers shall not enter into a partnership with a non-lawyer if any of the activities in that partnership constitute the practice of law. I'll repeat that. Lawyers shall not form a partnership with a non-lawyer if any of the activities of that partnership constitute the practice of law. And there are no exceptions to this rule. So let's be clear about this. If you're a lawyer and you enter into a partnership with a lawyer, no problem. If you're a lawyer and you enter into a partnership with a non-lawyer, the next question is, well, what is the partnership going to be doing? If any purpose of that partnership is to practice law, then it's in violation of the rules. Here, we're told this proposed arrangement would allow for the lawyer to do the legal side of things and the therapist to handle the therapy side of things. But they're going to work together. And that's a problem because, as we've just learned, a lawyer cannot form a partnership with a non-lawyer if anything that they do constitutes the practice of law. So, this arrangement is not proper. It is not okay. Let's revisit the call of the question to try to articulate an answer. So the question again states, is the attorney subject to discipline if he enters into the proposed partnership with the therapist? So I'm going to be looking for a yes answer because part of what this partnership sets out to do is the practice of law. So with that in mind, let's evaluate our answer choices. A says yes, since one of the activities of the partnership constitutes the practice of law. A looks great. It's exactly what we said. It's a great resuscitation of the rule, so let's hold on to it. But we're going to make sure that the other answer choices are wrong. B says yes, because the agreement constitutes a reciprocal referral fee agreement. Well, B is wrong. Reciprocal referral fee agreements are situations where lawyers and non-lawyer professionals refer cases or clients to one another. And there are certain requirements that must be met in order for these types of agreements to be proper under the rules. But that's what's not going on here based on our facts. The facts make this very clear that the therapist wants to enter into a partnership agreement with the lawyer. So B is not applicable. C says no, because both the attorney and the therapist are competent in their fields, and their letterhead and website make it clear that only the attorney provides legal services. So C is wrong. It doesn't matter that only the lawyer will be the one providing services, legal services specifically. The problem is they have a partnership, and part of that partnership's purpose is to practice law. So C is wrong. D says no, as long as the therapist does not provide legal advice to clients. And again, D is wrong for the same reason as C, because it violates the rule. Thus, answer choice A is the best answer. Turning to our third question, handling it in the same manner. The facts state an attorney represents a client in a contract dispute. The case has been going on for 2 years and is set for trial in 3 weeks. During the course of preparation for trial, the client has disagreed with every tactical decision that the attorneys made. After the most recent disagreement, the attorney felt angry and annoyed at the client and suggested to the client that she seek a new lawyer. The client was initially upset, but later agreed to seek new counsel. The attorney gave the client appropriate notice to find a new attorney and then asked the court for permission to withdraw. The court, however, denied the attorney's request. May the attorney withdraw from representation. So using our usual approach, we stop after we read that call of the question and we try to articulate what rule is being tested. This question is testing withdraw. Remember, there are 3 situations that require mandatory withdrawal, and then there's permissive withdrawal. We should start by double checking that this is not a scenario that requires mandatory withdrawal. Those 3 situations are if continued representation would result in a rule or a legal violation, which is not applicable here. The next is when the lawyer's physical or mental condition stands in the way of competent and diligent representation. And again, we don't have any facts that support that this situation is applicable. The third instance of mandatory withdrawal is if you're fired by your client. And here, that's not supported by the facts. In fact, the lawyer is the one trying to fire the client, not vice versa. So that means this is not a scenario for mandatory withdrawal. Let's evaluate those permissive withdrawal rules. When it comes to permissive withdrawal, the rules give us a handful of circumstances in which permissive withdrawal is acceptable. But please note that it's not exhaustive because the rule also notes that permissive withdrawal is appropriate if a good cause exists. I would say that if a lawyer and a client are disagreeing so much that the lawyer feels they can't do their job, that would be good cause to seek termination of that representation. In that instance, it seems like withdrawal would be proper. But that's not it for the rules, though. The rules go on to say that in order to properly withdraw, the lawyer must comply with their jurisdiction's applicable rules regarding notice and or permission to withdraw. This means you can't just unilaterally decide to withdraw. You have to figure out what you must do in your jurisdiction to effectively withdraw. Some jurisdictions require a judge to give you permission. Here, it sounds like we are exactly in that type of jurisdiction because the fact pattern tells us that the judge is not allowing the lawyer to withdraw. And that's all we really need to know to answer this question. So, just because the lawyer has good cause to withdraw doesn't mean that he or she can simply do so. The lawyer still needs to go through the motions of following the rules to effectively withdraw. And here the court is saying that the lawyer can't withdraw. And that makes sense because to give you more context, the facts tell us that trial is in 3 weeks. Allowing the client to get a new lawyer at this point is going to kick trial out even further and then therefore likely cost the client more money and waste the court's time. So there's a good reason here for the court to say no, just stick it out and you can't withdraw. So let's revisit the call to question. It states, may the attorney withdraw from representation? And we're looking for a no answer because while good cause may exist to withdraw, the lawyer needs to get the court's permission, which was ultimately not given. So let's turn to our answer choices. And we're just going to take it from the top. Answer choice A says yes, because the client has sufficient time to find a new attorney and agreed to let the attorney withdraw. So A is a decent answer in the sense that it's true. Lawyers do need to do their best to give the client time to find and secure new counsel, but that's not the only requirement for effective and proper withdrawal. It's just one. Answer choice B says yes, because the client's actions caused the attorney to be materially impaired from representing the client. Answer choice B is wrong for a few reasons. It's a yes answer, first of all, and we're looking for a no answer. And the problem with this is that there are more than one reason to seek withdrawal from a client. Here I would say that this lawyer has good cause based upon this constant disagreement between themselves and the client. But it doesn't really speak to the requirement of the lawyer going through the motions of getting permission from the court to properly and otherwise effectively withdraw. So as a result, B misses the mark. The other thing I would point out is materially impaired is something we normally see associated with mandatory withdrawal under those requirements, which again, we've decided mandatory withdrawal is not applicable to our facts. So overall, B is just not right. Answer choice C says no, because the attorney's request to withdraw was denied by the court. C looks pretty good. It's exactly what we stated. This attorney might want to withdraw, but the attorney needs the court's permission, and it was not provided. So let's hold on to answer choice C while we evaluate D. D says no, because further representation of the client would not cause the attorney to breach any of the rules of professional conduct or other law. Well, answer choice D is wrong because it misses the point that there are instances of mandatory withdrawal and then permissive withdrawal. So while continued representation here might not break the law or might not make the lawyer break some sort of ethical requirement, that's not the only instance in which a lawyer can withdraw. So answer choice D is wrong, which makes answer choice C the best answer.